Number 1, Mohammed Taif.
वन टू 9.2 तक सिर्फ सेकंड सेट का नहीं है, पता नहीं
क्या देखो रेरा एक्ट चैलेंज और रेरा एक्ट
सेंट्रल एक्शन टू बी
सब हो चुका कंफर्म सुप्रीम कोर्ट से।
जी जी डिक्लेयर सेंट्रल एक्ट नंबर 7 हाउसिंग लेआउट
Yes, who appear? You appear?
One serial number 1, 2, and 8. They pertain to RERA. This thing. Initially, they were deferred on the ground that a batch of petitions are being heard.
Supreme Court.
The Supreme Court had directed that let the Bombay High Court take up the matter first. Of course, now Bombay High Court has decided the matter, dismissing those petitions with certain observation. But I would request your lordship to kindly give me another week or 10 days time for this reason.
I understand in UP, Allahabad High Court, the provisions of RERA Act were challenged. That petitions were dismissed. And thereafter, the matter was taken to Supreme Court. There also, the SLP has been dismissed.
Supreme Court,
that has been dismissed. No, here the entire act is under challenge, not any particular section or any provision.
In the Bombay decision, that's what we found, that it was confined to some of the provisions only.
And there is no consequential relief paid. So in this manner, the petition itself is not maintainable. Entire act, how it can be prejudicial to anyone?
The present matters before your lordship, serial number 1, 2, and 8, are by housing cooperative societies, which are pleading that these provisions and the registration will not be applicable to them. On merits, that is the contention. Challenge is the requirement of registration under the RERA Act for these housing societies will not be applicable is the challenge. The Bombay judgment, of which I was able to secure the copy, this is not a matter dealt with. With regard to the other matter, I was not knowing. Therefore, would your lordship consider granting us 10 days or 2 weeks time? In the meanwhile, we'll verify the other matter. If it had gone to Supreme Court and something has been done, we'll make a submission. Otherwise, we'll give a written synopsis and
even otherwise it is not maintainable, but this is what we find. It is not only with respect to registration. It does not challenge the provision of registration, which makes the registration mandatory. It challenges the entire act as it is.
of course, the other
Without any
consequences which would follow if registration is done.
This special bench has been constituted.
As regards the Bombay judgment, my lord, I was able to secure it. This is not one of the points considered, not that it would be allowed or dismissed, but this is not one of the points that had come up.
Give time to them.
Yes.
After 1 week. You want 1 week time?
2 weeks.
Why no? These unnecessary. What is the point keeping them pending?
Please.
Given the time.
Yes, a straightforward learned senior advocate Sri Jayakumar Patil call on 11th March. Please.
To enable him
To enable him to file, to enable the AOR to file the second set and to find out and to complete instructions with regard to the matter pending in Supreme Court. Yeah. Sir, if it is
Friday. Not necessarily. Because we have given the roster to some other person. We have to split it.
All right.
Same order. 1, 2, and 8. Same.
1 to 8. All
1
right.
to 8.
9. All right.
Filed a memo for withdrawal. On memo, some objection is raised. I will attend to it. Petition may be dismissed as withdrawn.
Non-violent. This is now for withdrawal.
See number 10.
Please.
Dismiss.
Yes. Learned Sri Jayakumar Patil, learned senior advocate, submits that the petitioner may be permitted to withdraw this writ petition. Yes, withdraw this writ petition. Stop. Leave granted. Petition stands dismissed as withdrawn. No cause. All interlocutory applications stand disposed of.
11.
No, but what matter? What is the matter?
You have filed second set. Where is that? Second set is not here.
This one consequence.
ये क्या है क्या टाइपिंग क्या?
Section 2, 4, F3, F5.
Karnataka Cooperative. Your judgment is not covered. Section 4, 6, 7, 8.
Been decided. Section 2(4), prayer clause A. Also here, section 3, 4, 6. So many sections of Cooperative Societies Act are unconstitutional.
In fact, the amendment itself was silent. That amendment
No, it's all right that you can challenge the whole act also, but the point is, how are you affected by that? Challenge the wholesale. Please see prayer clause A, section 2, 3, 4, 6, 7, 9, 11, 13, 17. Then the entire book is gone.
How it is arbitrary? A special bench has been constituted to hear all these matters. We cannot adjourn the matters like this. We can. If you don't want to argue, don't press the petition. Already the validity of so many sections have been upheld, which was under challenge before the learned single judge. Judgment has already been pronounced, upholding the validity of so many sections. Now, if you have to argue anything, then argue it, otherwise not press this petition. Already we had granted you time earlier. On the last day, 3/2/2022. Now, after 1 month, we are having this matter again. How can we keep on postponing the matter like this? No, sorry. Then we will dismiss the petition. If you do not have instruction, then we will dismiss. Or if you want to argue, you argue it on merit. Then sorry then. This is an old matter, we cannot keep on pending. 2015.
You can give him one option. इसको छोड़ के it can go before single page. But if he has challenged some notice, etc., it can go before single page.
Don't press the validity of the provisions so far as the consequential relief which you have claimed. For that, we will give you liberty to press before the learned single judge.
Prayer clause C. You are aggrieved by prayer clause C. You can it can be considered by the honorable single judge.
So that at least this may not come up before the special bench.
File a memo to that effect, seeking instructions.
Can we record that? In any event, if it comes next time, this will be the only order. Be very clear about it. Because the entire book you have same day. As prayed for by.
Mr. AGA, what is the position, legal position, whether validity has been upheld of these provisions?
Several individually certain provisions are being challenged, my lord. In this case, Act 35/2014 itself is challenged. Whatever was amended under that. Otherwise, independently in service petitions, independently challenged.
You just look up and then tell us on the next date so that, all right. Yeah. And also remind us, we may not remember. Same day, as prayed for by learned advocate for petitioner. Same year to Sati Barle.
11.1, my lord, this pertains to the education fund, section 57 and 57A, my lord. We have filed the second set. I would request it may be taken up on any day. I will file a written synopsis. It's a matter to be argued, my lord. I would give the judgments and the written synopsis.
No, second set is here.
Yes, we have filed it. We have filed the second set and complied with the translation portion of it also, my lord.
Yes.
Your Lordship may kindly grant me a week's time or any other date that may be fixed. In the meanwhile, I will make the written submissions and the compilation of judgments.
What your challenge is proviso
Challenge is
to the proviso to
proviso to
section
section
57
57.
2A. Karnataka Cooperative Society.
By virtue of which they will have to remit 1%.
To be administered by the government through a cooperative society. In respect of this, a proviso is enacted saying pay additional 1% to a federal society. It's nowhere even government takes over the control of it. According to us, it is like a compulsory payment to a private society is the way it is, how it is done.
Comment say, have it say,
Point number 3, Federation. How the federation would be run?
Federation is
Maybe it is to run the federation.
all the urban banks together have constituted another
federation.
federal society.
Therefore, this provision has been made that what 1% of the profit you will give it to this
Effectively,
federation.
giving is
to
another
run.
thing. Voluntarily we giving is another thing, but the government levying it as fee or tax for the purpose of this
That is
society.
for your benefit only, because this cooperative
2% is
urban
already
bank
given.
federation.
2% education cess is already given. We have not challenged that.
No, education sense is something different.
No, this is again added as education cess. And there should be something like the money being taken to government.
Give the book, cooperative, 57, section 57 proviso. There must be some purpose.
57 2 capital A. A cooperative society shall, from out of the balance of its net profits, contribute 2% to the cooperative education fund to be administered by the Karnataka State Cooperative Federation Limited, Bengaluru, provided, this is the provision, provided urban cooperative banks shall contribute 1% of its net profit to the Karnataka State Cooperative Urban Banks Federation, in addition to the 2% as prescribed in subsection 2A.
This has been brought by Act number 35 of 2014.
Yes.
Now, where is Act number 35 of 2014? It must have been given the object.
That was in view of 97th Amendment to the Constitution.
There must be some object to this.
As regards education fund being
No,
constituted.
it's all right. Why it has been inserted? What is the object of inserting it? This is what we want to know.
Initially, they had inserted it by way of rules without there being a substantial provision. Along with some other this thing, that was challenged. Then they came up with a substantial provision, section 57, 2% is given. For urban banks, 1% additional.
Gazette
to
se
be
nikalwana
made.
padega, Gazette. You will have to take out from the Gazette the object of the Act 35 of 2014. What is the object?
The object is in view of the 97th Amendment to the Constitution, bringing it to go cooperative under Article 19C with regard to cooperative system. Subsequently, 243 Amendment. So far as 97th Amendment is concerned, so far as Part B, 43B is also inserted. This amendment is to bring in consonance with 97th Amendment to the Constitution.
Does it provide that amendment, constitutional amendment provides for this?
Certainly, madam. 43B and
Now that part 9B, as far as states are concerned, it is struck down.
by way of 97th Amendment to the Constitution, Article 19, 1C, to form association and unions or cooperative societies. This was inserted. 43B, this will still hold the field. 43B.
Shashikumar, what my lord is asking is, this provided this proviso, it says that they will give 1% of this net profit to Karnataka State Cooperative Urban Banks Federation. What is the nexus?
But primary society, secondary and federal. The overall objective of the cooperative movement is to see to it that all these societies function, because a member, an elected director from primary society would also go into the secondary society and to the federal society.
What is the education fund to do with that? No, sir, you must put it in record. You must file an affidavit to this effect. This is the constitutional mandate. This is a object that is achieved to be sought to be achieved. This is the nexus. Therefore, this is in intra-virus. You must satisfy to that extent. Otherwise, simply tomorrow you will add another proviso, give 10% to so and so.
In fact, at the time of preliminary hearing, I myself made a suggestion. Please make this 1% payment to the government. Thereafter, you may transfer it to federation or anybody. Because you are taking it as a fee, it cannot be in favor of some society. That federal society is not, a government is not a shareholder. It's a independent like any other cooperative.
Under subsection 2A, 2% education cess is also given to the federation only.
No, administered by federation. It's given to the government and
Shall from out of the balance of its network contribute 2% to the cooperative education fund to be administered. Administered by Cooperation Limited Bangalore. We can read it to the extent
Yes.
that it may be given to the state government, which may you will have to also, in fact, defend it, how it can be given directly to the society. Prima facie, what the learned senior advocate is saying is correct, because whatever the amount is to be given, it has to first go to the state government. From there, it may give it to the federation.
Another proviso, provided further that the total contribution made by the cooperative society to the account of the cooperative education fund every year, 1/4 shall be remitted to the account of Sarkar Academy registered under the Karnataka Society Registration Act 1960 and sponsored by the state government for the purpose of carrying out cooperative education, training and research.
That pertains to 2%. That is why I said, even for this, something of
That 2% also goes to the state government. From there, it is given to the federation for its administration, to administer it. The same way it can be done, we can read it down to that extent, provided you take this stand. Unless, otherwise, we will have to struck it down.
It's like,
But if the state government says that now, in fact, the purpose is to just maintain these federations, and therefore this cess has been created 1% to give it to the federation, then we can read it down to that extent that it will go to the state government, and the state government may give 1% this thing to the federation.
and thus distinction only for urban banks, somewhere where the state has no share capital in anywhere.
Any other bank? We will have it again. Learned AGA. Praise what is allowed. A week's time to file the statement of objection, clarifying the stand of the state government as to how the 1% of the net profit can directly be transferred to the what federation?
Urban Bank.
Urban and Cooperative Federation.
Urban Bank Federation. Karnataka State Cooperative Urban Bank Federation.
And what is the purpose of the amendment brought in the
By way of this provision.
section 57 Cooperative Societies Act 57 2A by Act number 35 of 2018 14. We are giving you 1 week time. कब लगाया वो?
11.
Same day.
Is it to be delinked from 11.1?
Hmm?
This is 11.1 minus. Is it to be delinked from
No, no.
11?
There is an application for dispensation of translation of a souvenir that is produced, which is of no relevance with regard to the question involved.
All right. then.
In 11.1,
11.1,
Lordships passed the order.
11.1, let it remain as it is.
Please.
We'll consider the next day. No, 12.
Serial number 12, my lord, we have filed the second set and the translation of the relevant this thing. There are a demand issue for all the societies, about 28 societies. We have furnished the translation of one copy, and for others we have sought for dispensation.
All right. Striking down the provisions of Karnataka Act 35. Section 12.
This, my lord, your lordship may fix it upon 7th. In the meanwhile, I will file the written submissions also. This is a matter to be considered.
Order.
The subject matter is this, my lord.
We will fix it on 11th itself, because then again the bench will have.
Please, my lord.
11th we will take up all
I
the.
will furnish the
Meanwhile,
written
you prepare
submissions
the
also.
written submission.
Have you filed your affidavit, learned AGA? Fine. All right. See, now in this, what you are doing is, you decide what the bylaw should be. You approve yourself. And then tell them that it will automatically come into your rule book. No, whether it is in consonance or otherwise, prima facie, a cooperative movement is like-minded people for a purpose. They will join hands and do something. You are there for some regulation, some irregularity is there, some section 70 is there, surcharge proceeding is there. You have to only regulate or in the event of large institutions, administration. You can't decide what bylaw a society must have, prima facie. You may, if you have any other view, that's a different matter. This is what Supreme Court has said in more than one decision.
Bylaws has to be prepared by the society itself. You cannot provide the bylaw.
Parsi Baba case judgment. Parsi society. Way back.
That is the law. Society. Bylaws has to be prepared by
Yes.
the society.
As prayed for by the senior advocate, call on so and so date.
Just on 11th.
Number 13,
Serial number 13, I am yet to file a translation, my lord. It's very voluminous. Today, actually, we have received the translation. I have not been able to verify it.
11th.
Please.
Counsel for the petitioner wants a short accommodation to file the translated copy of the documents. On his request, case adjourned, list on 11th.
14,
Kindly place a 3 weeks time, my lord. Need to file second set of writ petition and translated copy, my lord.
Time was granted to you.
Not it was furnished to the client, my lord. He didn't give in time in regarding to that, my lord.
No, yeah, 1 month has passed.
No, he didn't furnish back to us. He has not reverted back. That's why.
क्या कहते हैं?
He has not reverted back, my lord. We have given the copies to him, or typed copy.
To whom have you given the copy?
For the clients,
For what?
for the translated copy.
Then we will dismiss it for want of instruction.
Because that he is not keeping well, my lord. That's why, my lord. Kindly press a 2 weeks time, my lord. I'll do the needful.
You are not having instructions to argue the matter. Your client has not turned up.
No, man. Yeah, I need to file a translated copy, my lord.
Please remove the mask, then speak so that I can understand.
I need to file the translated copy, my lord.
Why you have not filed it?
Given to the client, my lord. He has not given it.
He has not returned to you. No, what can be done? Let it be dismissed.
My lord. It will be complied by 2 weeks, my lord.
1 month has passed. Special bench has been constituted. It is not a regular bench. Date was fixed 1 month back. You have not been able to do it. You say that your client has not turned up.
2 weeks time, my lord.
Post it on 11th. It's just
11th. All right.
last opportunity.
Yes, ma'am.
Counsel for the petitioner, principal is allowed 1 week and no more further time to file this translated copy of documents as well as the second set of writ petition, failing which the petition will be dismissed on the next date. List on 11th.
Number 15.
I pray for the petitioner, my lords. I pray for 1 week time, my lords.
Same order.
For
1 week and no more. Failing which
Please,
petition
ma'am.
will be dismissed.
Please, ma'am.
Number 16. Between associates.
What is
Consumed order on Annexure G. Therefore, the issue is declared section 14(5).
cooperative? Structures हो गई होगी petition. Consequential order stay तो है नहीं. Is there any interim order?
Just check in the order sheet. Order sheet.
Annexure J. ये कोई 5/1
2015.
अच्छा देखो structures. तो निकालो where is the interim?
Yes, sir.
Interim order. What is interim order?
This is Aircraft Employees Societies. सरकार संघ he has divided two societies. What has happened to this, Mr. This was coming when before when you are arguing this matter, this aircraft matter.
This is not this is regard to challenges
Splitting that society.
amalgamation.
Amalgamation. So now in this case it has been split. So if there is no interim order, it must have become infructuous. 2015.
Wait a second. Is there any interim order operating? There's no interim order. No interim order, no? That is why you
Certain?
lost interest.
If you are sure, we can record it. Correct? Huh?
To take this out. Otherwise, we'll dismiss it for want of
Correct.
prosecution.
Non-prosecution further.
Second writ petition has been filed seeking following relief from the, no one has put in appearance on behalf of the petitioner to press this writ petition. From the order sheet, we do not find any interim order operating in the writ petition. It appears that with the passage of time, the writ petition the petitioner has lost interest and the writ petition itself has become infectious. The writ petition is dismissed for in default as well as for want of prosecution.
That is CMO to amending the registrar amending. Same thing. 11th. As prayed for call on 11th.
Connect कर दो ना उसको.
Yes. Post along with.
Serial number.
As prayed for post along with the serial number 12 and call on 11th.
18.
I appear for the petitioner's counsel, my lord. This very question is now before a special bench. Matter is because of certain directions by the Supreme Court. Writ Appeal 416 of 2020, your lordships have constituted a special bench. It's being heard. This may be adjourned by about 3 weeks, my lord. If that is decided, we'll file a memo. Otherwise, it can come. Section 18B.
It is submitted by learned senior advocate that
Writ
the
Appeal 416 of 2020.
issue in this writ petition is under consideration by a division bench in writ appeal number
416 of 2020.
call after 8 weeks with liberty to mention after disposal.
The interim order may continue.
All interim order granted earlier shall continue.
Please.